the guidance.
The Joint Parliamentary Committee handling the amendments to the UPDF Bill 2025 reconvened today with the Attorney General to seek further clarification on unresolved issues from their previous meeting on Wednesday. Senior military officials also attended the session. A key point of contention remains how to differentiate ordinary items such as shoes and counter suits from military gear to avoid civilians being charged in military courts for possession of military items. The Attorney General provided legal guidance on the matter.
Part should be that all the military stores must be properly inscribed with UPDF, and that has to be added into the bill in order for it to have.
Inscribing the word UPDF on those items, it does not reflect anywhere in this schedule 7A.
However, Attorney General Kiryowa Kiwanuka appeared to reverse his earlier position while noting that members of parliament should handle the issue of military stores with care.
For example, the issue of the beret. As long as the beret does not have that insignia or emblem, then it's not UPDF.
Now, it may seem like we are discussing the red beret right now, but how is he, the soldier who is guarding you, to know if he finds 100 people and all of them are just saying these are not military stores?
Kiwanuka also defended the prosecution of civilians in military courts, mainly citing cases where individuals are found in legal possession of firearms.
What the government is saying is that these people who use these illegal firearms, in concert with soldiers, let us deal with them as what? As soldiers. But we are not saying that soldiers should not be treated as human beings. Soldiers also need fairness and justice.
The committee also engaged with officials from the Office of the Director of Public Prosecutions, the DPP. They argued that cases listed in the UPDF Act should be handled by the military courts. They warned that expanding the jurisdiction of the court-martial could lead it to handle even corruption and other civil offences. The proposed amendments list offences such as murder, aggravated robbery, kidnapping with the intent to murder, treason, misprision of treason, and cattle rustling.
Only difference is that where these courts operate elsewhere, their jurisdiction is well defined. It is not all over the place. And that is what the Supreme Court is telling us.
Giving such a wide jurisdiction is likely to create confusion in the administration of justice. The provision would mean that the General Court Martial can even try corruption-related offenses under the Anti-Corruption Act.
Concerns were also raised about the lack of judicial independence in the military courts since the judges are serving military officers appointed by the Army's High Command. Critics argue this undermines the prospects for fair trial.
To mitigate their perceived fears of partiality, there is a need to strengthen the tenets of independence of the General Court Martial. We recommend that a specific provision in the terms equivalent to Article 128 of the Constitution be inserted to guarantee independence of the General Court Martial, provide for non-interference in the performance of their judicial function from third parties.
The most important issue that I see in this whole thing, in this whole process, is how do we build the confidence of the public that when I am taken to the court-martial, I will be treated justly.
One member of parliament proposed that before finalizing the bill, legislators should visit civilians currently imprisoned through military court processes to better understand how their cases were handled.
These people in these prisons that have passed through the general court martials or through the division court martials, it would be important, Mr. Chairman, that this committee doesn't process this bill before visiting the people, even and listen to them. Those that have been sentenced, how did they go? Who was even the prosecutor?
Meanwhile, MPs rejected a proposal by Mukono Municipality MP Betty Namboze to summon the Chief of Defence Forces, General Muhoozi Kainerugaba, for his views on the bill.
And I wish to move that among the people this committee interfaces with during this process, includes the Commander of Defense Forces of Uganda, General Muhoozi Kainerugaba.
To implement, the person who will be consulted when it comes to the appointments according to the bill, I do not see any wrong of calling him for us to summon.
In favor will say aye, and to the contrary,
you
nay.
are still teaching us on how to vote. He hasn't called the vote.
An open question remains whether the law, if passed, will apply retrospectively. The Supreme Court had earlier ruled that such cases should be transferred to the DPP, who has so far received 45 cases since January. However, only 2 have proceeded to trial in civilian courts. Juma Kiryowa, NTV.
Have you been